Payne on behalf of the district judges.
Thank you, Your Honor, and may it please the court. My name is William Payne, and I represent the state district judges in this case. For my clients, the easiest way to resolve this case is to follow this court's recent en banc decision in Daves, which establishes that under Section 1983, district court judges acting in their official capacity in their judicial roles are state officials and are therefore not persons subject to suit under the statute. Additionally, there's a standing problem under Daves because the alleged injuries are not fairly traceable to the district judges, and there are serious defects to the class certification order because of Galveston County's post-O'Donnell policy changes. I'll turn first to the Section 1983 issue. Daves significantly narrowed O'Donnell's definition of whether official acts as a policymaker on behalf of a municipality rather than in a state capacity. As in Daves, the district judges here act in their state judicial capacity when they are exercising their judicial authority or adopt procedures in a capacity inextricably linked with that authority and are thus not appropriate defendants in this case.
So, as you may recall, in Davies, we remanded the case in part to the district court, and the district court actually issued its opinion and said that Senate Bill 6 kind of moots all of this. Obviously, I don't know what the en banc court will do with that, but let's just for a moment assume arguendo we end up agreeing with that. How does that impact this case, if at all?
Well, Your Honor, at the outset, I'd like to say that my colleagues over here have addressed the mootness issue in much greater detail than we have. That said, SB 6 does attempt to address some of the changes brought on by this court in O'Donnell, and therefore I think it's appropriate in this case to consider whether SB 6 has addressed some of the concerns of my colleagues on the other side in terms of whether people are falling through the cracks.
Well, and I'm wondering whether it changes the class, because obviously it's a little hard because we're only dealing with the 23F and there's some other panel dealing with the preliminary injunction, so it's a little complicated. I got to keep my head on one thing, the class certification. Does it change the class? Because the class that existed a while ago doesn't anymore because of SB 6, or does it not affect the class?
I agree with Your Honor that it is, sorting the class and figuring out who is in it is definitely a difficult question. I would agree with you that SB 6 arguably creates instead of just the bifurcation of the class based off the change in Galveston County's October 2018 policy change, that it arguably creates a third, another division within the class, for those who are subject now to bail administration after the enactment of SB 6.
Okay. All right.
As for standings, Daves establishes that if the causal relationship between the injury and the challenged treatment of pretrial arrestees depends upon the discretion of independent third parties, such as a magistrate making a bail determination, then tracing the injury beyond the magistrate is too speculative to establish standing. Turning to the substance of the class certification issue, the class certification order failed to conduct the sort of rigorous analysis required because an adequate analysis would have found that the certification was foreclosed because of a lack of commonality and typicality, as well as the impossibility of providing relief to the class as a whole, thanks to Galveston's adoption of new bail procedures after this court's decision in O'Donnell.
Okay, so let me ask sort of two related things. Should we put this case on hold until the en banc in Davies finalizes whatever it's going to do? And or should we just remand and say, think about Davies first without ruling on all the details until the district court's done that?
Your Honor, I think this court has enough before it to vacate the class certification order even without that. I think that at this point, we know that there's enough differences between the class members, say in the 14th Amendment context, the class members who were magistrated before October 2018, that happened a long time ago, those issues are moot, whereas those magistrated under the procedures adopted after O'Donnell, they're complaints are foreclosed by O'Donnell itself. Similarly, in the Sixth Amendment context, it's our contention that all class members should have their claims foreclosed by Rothkari as well as Texas state precedents, but there's also a lack of commonality and typicality because the interests are very different for those magistrated before the policy changes, when potentially they could have been waiting a number of days, weeks, or months in order to get counsel, versus those who were magistrated after October 2018, when they had to wait a maximum of 48 hours and more usually like less than 24 hours before they obtained access to counsel, which means that there's no relief that can address all of the members of the class. So therefore, that's why we think the order should be vacated, even under the information that we have now, regardless of Dave's. With that, Your Honor, I will take my seat and defer to my co-counsel.
Okay, thank you. Now we've got Mr. Reddy for the county.
Good afternoon. May it please the court. Paul Reddy for Galveston County, Texas. I'd like to begin by addressing your questions, Judge Haynes. Does SB 6 moot the case? Yes. I mean, the case is moot for two entirely separate reasons. One of them is the facts on the ground in Galveston County are different than they were in April of 2018 when this case was brought. And since this is only a forward-looking class, that seriously affects how the parties are situated. As well, in August of 2021, the Texas legislature passed SB 6, which affected the law in Texas about how people should be magistrated. So now neither the facts and processes on the ground nor the law are the same as they were when Aaron Booth went through the system in Galveston County.
So, Counsel, do we send it back for the district court to deal with it, or do we address the class, or do we just say, well, it's mooted and we dismiss it? I mean, what's the disposition?
My first line is, it is moot, and so it should be dismissed. If the court decides it is
Vacate and dismiss, right?
absolutely,
Yeah.
it should be vacated and
That's what you're arguing. I'm not necessarily agreeing. Just
yes,
that's what
Judge.
you're arguing. Go ahead. Okay,
Go ahead.
and while you're answering that, I noticed that the magistrate judges have just kind of been following you around. Are you going to address their aspect of it, or are you just talking about the county?
Yes, Judge. I'm here to speak on behalf of the magistrates as well, which is a
Okay, so because the magistrate judges weren't addressed in Davis, so I'm just wondering, do your arguments cover them, even assuming arguendo they could be sued in an ordinary case? Is it your position that because of SB 6 and the Galveston changes and so on and so forth, whether or not you could sue magistrate judges in some other case, you can't really, it's done here, it's moved?
yes, Judge, and for reasons that are both broader in application and more specific to this case. I'll start with the ones that are more specific. What's peculiar in this case, and potentially different from even Dave's, is that the trial court has dismissed the magistrate judges in their official capacities, but not their individual capacities. So if we're to apply Dave's and say their general sense that came from the Dave's majority opinion that says that even a local judge, when they're acting under state law, is a state actor, and when they're deciding bail in a case, they're acting pursuant to state statutes, therefore they're state actors. There's no reason for us to come to a different conclusion with magistrates than we did with county court at law judges, say, in Dave's, or with district judges, because they're all performing the same functions, similarly situated. But if we land them in that state actor bucket, under Ex parte Young, you can only proceed to get your declaratory and injunctive relief against a state actor in their official capacity. We only have the magistrates in this case in their individual capacity. And so we can't hit that exception for Ex parte Young in their case. As well, that also negates redressability. They have no relief to offer in their individual capacities. They could only offer relief when they're sitting as a magistrate judge. And so they're really not here in a capacity that would let them survive review.
But is the mootness argument any different as to them?
No, it isn't, because the magistrates are part and parcel of the same process, which I will say, if we're crossing, mootness and redressability, these issues sort of bleed over. The magistrates we have in this case are only 3 of the dozens of people who are qualified to act as magistrates in Galveston County, And the trial court, when it crafted its TI order, even sort of recognized this order can't apply to magistrations that are occurring outside of the Galveston County Jail and any of the outlying municipalities that choose to conduct their own magistrations. So if we're saying, let's look at the body of people who are being magistrated in Galveston County, we don't have the parties in front of us who could afford relief, right? And to the extent we're talking to say, okay, let's imagine we can look narrowly at the universe of people who are magistrated in Galveston County and only consider—
Please don't drop your voice.
Sorry, Judge.
You got the mic turned in the wrong direction, so.
Even if we only consider the people who are magistrated inside the Galveston County Jail and put our blinders on to the fact that the rest of the county does things differently, these magistrates exist under a process that is different than it was in April of 2018, and that is undecidedly true, or undisputably true, I'm sorry.
Okay.
And because the process is different, the question that's before the court is to evaluate the adequacy of the system Mr. Booth didn't go through, and laws that didn't apply when Mr. Booth was
And
arrested.
so does that affect the class certification because Booth couldn't represent the people that are now impacted by whatever the world is?
It's both, but jurisdictional issues are threshold questions. We can't certify a class when we don't have subject matter jurisdiction.
Right, I'm well aware. Okay, thank you. It's just we have to ask all the questions because we only get one oral argument, usually. Okay, Ms. Olalde?
Olalde, Your Honor.
Okay.
May it please the court. It seems like the court's struggling the most with what do we do with this case? Do we keep it? Do we send it back? Do we
Well, that's what we do with every case.
So here we are right now in a situation where Galveston was ahead of the curve, right? You have SB6 is over here on the side later on in time, but Galveston was ahead of the curve, and we have mootness already teed up in front of you. But on a class cert appeal, on a 23F appeal, you have to address the standing, mootness, all of those Article 3 questions. And to kick it back on a record in this case, we had a very long preliminary injunctive and class certification hearing. We have ample evidence in the record, and we have the district court's subsequent findings as well to allow the panel at this time to take a look at the district attorney's standing, to take a look at mootness, and analyze it within the context of this constitutional floor. Remember, it's a 48-hour constitutional floor under Walker, which applied the McLaughlin probable cause determination. And so here we are in Galveston County. We have 12 hours in front of initial magistration. We have 24 hours with a counseled bail review hearing. And so within those parameters, SB6 does not alter the court's analysis other than to, as counsel for the judges said, is to further fracture an already fractured class. But with respect to the district attorney in particular, I did want to make a quick point about the disconnect between the challenged action that we have here and plaintiff's claimed injury. The district attorney is in this case because he asked his prosecutors to look at a bail schedule when they exercise their prosecutorial function of recommending bail. That's it. And there is a huge disconnect between that and the claimed injury of having a magistrate not consider ability to pay in issuing a bail order. And that disconnect is fatal to a standing analysis. Oh, sorry.
You still have 2
I
minutes.
still have 2 minutes.
The
Thank
yellow button doesn't warn you of that.
I jumped the gun. There is no fairly traceable link, right? So plaintiffs still have this burden, and we're going to hear a lot from the plaintiff's side where they're citing back to the memorandum and recommendation on the motions to dismiss, which accepted their allegations as true. But remember, we're beyond that. We're beyond even a summary judgment proceeding because we have findings from the district court. We have a hearing in front of the district court. And so we do not have a fairly traceable link. They have not met that burden to show that there's any coercion on behalf of the district attorney to make the magistrates do anything, or that there's even any control on behalf of the district attorney to make the magistrates do anything in this process.
Yeah, I mean, it's a little bit of an odd notion that the district attorney is going to, I don't know, be in charge of the judges. But I'm sorry, you had a question.
Well, no, I was going to say, it sounds like then the district attorney falls into the same bucket as the district court judges and the county court judges at law under Dave's, right? There's just that, there's no link between the alleged causation and what they do.
That's absolutely true because all of these analyses, they kind of overlap, so it's hard to pinpoint where do we go first, right? But that's absolutely right. You do not have a state actor in the district attorney when he acts in his prosecutorial function. And so you don't have 1983 liability, but also you don't have
Wait, the district attorney is a state actor or is not?
is a state actor, absolutely, when recommending bail. And we have that holding in Hart v. O'Brien and in numerous other cases that we've cited in our briefing. The same issue comes up with redressability. In redressability, what order could the district court enter against the district attorney? Don't recommend bail? We don't like the way you recommend bail? There is no order that the district court could make against the district attorney to fix the claimed injury in this case. I see I'm out of time.
All right, thank you. Well, Ms. Trigilio, you got a lot on your plate here.
I certainly do. It's Trigilio, Your Honor.
Trigilio, sorry. All right, so go for it.
All right, good afternoon. Trisha Trigilio for the plaintiffs. May it please the court. I'd like to start with the court's questions about what to do with this case given yesterday's ruling on SB 6. The most important fact for this court to consider is that there are no facts in the record about how the passage of SB 6 has affected the procedures in the Galveston County Jail. And that matters because this court only loses jurisdiction over an Article 3 controversy if it's absolutely clear that this court could grant no effectual relief whatsoever. And for that reason, both questions about the way that SB 6 has affected the procedures and questions about the way that the evidence of bail review procedures has affected things in Galveston County both fall short of the standard that the defendants have to meet to prove that this court has lost jurisdiction over the live controversy that existed at the time of filing. So with respect to the court's question about can we just decide the whole thing on mootness now under SB 6, the answer is no, because there's no evidence in the record of how this bill has affected what's happening in Galveston County Jail. We've heard representations.
Well, so should we send it back? Should we just send it back without ruling on any of this and say, hey, take another look at this class?
Yes, and that's the way that this court proceeded on Banc in Daves. The court recognized
Well, no, they had a few comments along the way. They ruled
certainly
on
did.
A lot of stuff and then said, and we're sending this back. So, and as you know, I didn't join in that, but I'm bound by it. So here, why are we sending back the district judges since Davies has said, hey, you can't sue them?
Because the standing against the district judges here is completely different than the standing argument against the district judges in Daves. The standing here depends on far more than mere speculation. The rules at issue are different, and here the defendants have effectively documented evidence of standing for us. First, with respect to the rules, the bail schedule at issue in Daves urged discretion. The rules here in Galveston County eliminate discretion. They invite constitutional violations, and magistrates reacted in a predictable way by following what the rules instructed them to do. If there was any question...
But they deny that. I mean, they say the rules don't cover them.
They have denied that they followed the rules by automatically adopting the district attorney's pre-printed bail amounts, but the district court disagreed, and that's because of the abundance of evidence in the record showing how magistrates reacted in predictable ways to the passage of these rules. Most importantly, in the years before this litigation, the county retained a consultant to study why they had an overcrowding problem in their jail. One of the conclusions that that consultant reached was that magistration had historically not involved an exercise of discretion, and instead pretrial detention in Galveston County was driven primarily by the bond amounts that the district attorney had his prosecutors pre-printing on the form orders that the rules required the magistrates to use to set bail. The district court credited this evidence. The district court found that magistrates had been automatically adopting these bail amounts, and that finding was further supported.
Then how does that change the fact that in Davies they said you just can't sue district judges because they're state actors?
Daves held that there was no evidence in the record supporting standing against the district judges because there wasn't evidence that the magistrates had reacted in a predictable way.
But it wasn't an evidentiary holding. It was basically a holding that, as Judge Haynes just said, the district judges, the county court judges were acting as state officials, and therefore they weren't amenable to suit under 1983.
The court, well, there's a separate question about whether the judges were acting for the county and standing against the county. But with respect to standing against the district judges alone, the court was applying the standing rule from a Department of Commerce case, which held that there is standing to challenge government action when it has a predictable effect on third parties that causes them to injure the plaintiffs. And here there's evidence of that predictable effect in the record.
You can't sue them under 1983. So there's two different issues, kind of can you file the suit and is there standing in the suit? But those are all jurisdictional, but they're kind of two different issues. How do you distinguish Davies on that?
And so, Your Honor, if I'm understanding the question correctly, is the question about Article 3 standing or whether or not the district judges are county policymakers? I will say
are they state court actors in this context? Davies says yes.
They are not state court actors in this context because they're exercising completely different authority under state law. Davies was clear, held that the passage of the bail schedule, because it was guidance about exercising substantive discretion, that was just an exercise of the judicial power on behalf of the state. Here, what the judges are doing is fulfilling a duty under state law to pass local rules of administration under the Court Administration Act, which instructs them to pass rules of administration by county. And this is
how is that any different than what was going on in Davies?
It's different because the rules don't involve any substantive guidance about how magistrates should be setting bail. When you look at the...
We're going to determine county by county and locality by locality whether judges are acting as state actors?
It's not a locality by locality question. It's a question of what authority the policymaker is exercising under state law with respect to the function at issue. So when you look at the bail schedule at Davies, it looks very much like it's talking to judges about how to exercise discretion. The rules in Galveston County may as well be talking to robots, and that's important because counties can be liable for administrative acts but not judicial acts. The rule that was being applied in Davies comes from the case of Davis versus Tarrant County that said to figure out whether a judge is acting in a judicial or administrative capacity, you ask two different questions. One is, what is the functional effect of this determination when you look at the system as a whole? The other is, what's the nature of the determination that the judge is making? So first, with respect to the functional effect, Davis said, okay, if a judge is deciding to put an attorney on the wheel for appointments, that's functionally going to appoint that attorney in specific cases. That's a judicial act. Here in Galveston County, the functional effect of passing the local rules of administration doesn't determine what specific bail amount will be set in any particular case. And that's a really important distinction from Dave's. Second,
tell me this then. So, standing aside, we still have the issue of mootness. And, I mean, particularly I'm thinking of the equal protection claim and the due process claim. What relief has not already been granted by Galveston County in its reforms in 2018? In other words, tell me how those claims are not moot.
So the bail review procedures are deficient in many respects. They fail to provide counsel and magistration, which plaintiffs claim is required both under due process and under the Sixth Amendment. They fail to provide for substantive findings of necessity at any bail determination, whether at magistration or at the bail review. And they fail to provide bail review hearings for all class members. In addition, everyone agrees that these rules are not binding. So the case law is clear that when defendants make inadequate and voluntary changes like this in the course of the litigation, they don't deprive the federal court of its power to determine the legality of the defendant's practices at the time of filing. And for that reason, it wasn't an abuse of discretion for Judge Edison to certify a class to determine the constitutionality of Galveston County
But it's
practices.
a forward-moving class. It's not like a class that was injured in some, accident or something like that affected a whole county or whatever, and they're suing for damages. This is a forward-moving class, right?
That's correct.
There's nothing to do to correct Mr. Booth's situation in 2018 of not getting a fast enough bail hearing.
It is a class seeking prospective relief. All of the case law on voluntary cessation concerns plaintiffs seeking prospective relief. The question is, if the case goes away and we allow the defendants to effectively avoid judicial review by making tweaks that don't remedy the plaintiff's injury.
Well, that's the question. Is this true? I mean, I guess I'm sort of wondering why y'all didn't work this out. I mean, you got a lot of what you were asking for. The O'Donnell case, I still think was a good opinion, had an impact on a lot of counties, and that's lovely. So, and then SB6. So I guess what I'm wondering is if they made every change you wanted them to make, you still would say we want this because they could change it back. But isn't that sort of, I mean, with counties and cities and states and the U.S. government, with government, we always are a little different. We don't keep punching them even though they could change. I mean, you can always change. So the notion that you can always get an injunction no matter what else has happened, I mean.
I have two responses to that observation.
Okay, thank you.
One is that it's not true that the defendants have given the plaintiffs everything that the plaintiffs contend is constitutionally required. The list that I just went through are some of the highlights. In addition, the implementation of the procedures that was shown at the class certification proceeding fails to give class members the notice of the nature and the meaningfulness of that financial affidavit that's required under O'Donnell. But in any case, to answer your second point, which is, well, if the defendants make changes, how are we supposed to know whether they're permanent? The Supreme Court has identified many factors that tell us if any of these is present, then the defendants haven't carried their burden to prove voluntary cessation. If the defendants continue to defend the constitutionality of their original practices, that's a sufficient reason to say they haven't carried their burden. If the defendants refuse to adopt the change as an official policy, that's a sufficient reason to say they haven't carried their burden. And that's happening here. You know,
So they haven't? I thought they did adopt, not maybe everything, but adopt a good percentage of this.
that's a critical point, Your Honor. The bail review procedures have not been officially adopted in any way. Judge Edison asked counsel for all of the defendants about this at the class certification and preliminary injunction hearing.
Because they're saying they have been.
They conceded that the revised bail procedures have not been officially adopted.
You're saying it's the officially adopted, it's not that they are doing it.
That's correct. It's the
What is it that you want them to do exactly that would
They
that would
should
move this
adopt the revised bail procedures to be part of the local rules, which the local judges have refused to do. They should concede that their prior practices were unconstitutional, which in openings at the class certification hearing, they refused to do. They should provide the plaintiffs all the relief that plaintiffs contend is constitutionally required on a permanent basis. I mean, recall the district judge had to enter a preliminary injunction requiring the defendants to provide counsel at initial bail hearings.
Oh, but the district court in that preliminary injunction found that the changes were permanent, right?
The district court made a preliminary finding that a preliminary injunction wasn't required to give plaintiffs relief during the life of the litigation. But that's a very different question than the question of whether a permanent injunction is required, because the defendants might revert back to their old ways when the litigation goes away.
Isn't that always true with government? I mean, the Congress can pass a bill today, and then they can change that bill next year. I mean, that's sort of always true, but we got to kind of live with the world we're in.
Legislation and other official policy changes are ordinarily accorded a presumption of good faith when we're talking about the government, and that is correct. But there needs to be an official adoption of the policy, and here the defendants have consistently refused.
So tell me specifically who is supposed to do what. I mean, let's assume arguendo that what they're contending is the proper rule, but you don't think they've done it officially. Tell me exactly who should do what.
The felony judges need to amend the indigent defense plan to ensure that counsel is appointed before any bail determination. The felony judges should also instruct the magistrates that they need to make findings of substantive necessity before issuing any pre-trial.
This is exactly what we said in Davies. Davies that we can't make them do.
Well, Davies didn't actually rule on the merits of that question, Your Honor.
Yeah, because it said they couldn't be sued.
Yes, because we couldn't make you do that, even assuming arguendo that you should do that.
Right, and so shifting back from the merits to the question of whether the felony judges can be sued, the function at issue is the question under Davies, and the function at issue here is distinct from the function at issue in Davies. Davies held that the felony judges were exercising judicial authority by passing that bail schedule because it contains substantive guidance for how bail should be set in individual cases. It is intertwined with that judicial act. Here, what we're looking at is passage of rules that are designing workflow for the court. It's about what forms to use and who to give them to and when. And when you're looking at a decision that could be made equally well by a clerk of court or another private party, the Supreme Court has said you're looking at an administrative act and not a judicial act. That's under Ex parte Virginia. There's a robust body of Supreme Court precedent that says there's a principled distinction here between judicial and administrative acts. Rulemaking is not judicial. Overseeing the efficient operation of a court is not judicial. And if we know that that's binding precedent, this court should be careful not to interpret the Dave's opinion and expand it too far because it might bump right up against what we know is binding precedent.
Is it your position that the state district judges in this capacity are county officials?
Yes.
Okay. Davies didn't buy that.
That's correct, but it was for the exact reason that I was just describing.
Okay.
Here, the action that we...
So we're kind of looping around. Okay, I get that. Okay.
Okay, well, I'd like to reiterate, if there are no further questions about the district judges, that because there are no facts in the record about how SB 6 has affected procedures on the ground in Galveston County, we can't effectively oppose any arguments about the fact that SB 6 has mooted.
But should we just remand all of that? Say, you know, the 23F motion was improvidently granted, and we're going to remand this to consider all of this, or something like that.
Well, remand for consideration of the impact of SB 6 would be appropriate, but on this record, the court should affirm the class certification order because it wasn't an abuse of discretion.
Okay.
To talk about that a little bit, because as counsel opposite has said, Galveston comes in 2018 before the class is certified, and they change the procedures. And now we have this forward-looking class that at least a good portion of the relief that they want has now been implemented by the county. And so how is there commonality and typicality between people who were subject to pre-2018 procedures and post? Put SB 6 aside, but that further fractures the class, I think, as counsel said.
Absolutely. Putting SB 6 aside, the reason that that was appropriate is that there's still a live controversy over the practices at the time of filing. And getting a little bit more detail.
Yeah, but the class includes people who have nothing in common because they're pre-2018 and post-2018, right?
What they have in common is the risk that the defendants haven't finally terminated those prior practices, and that if the lawsuit is dismissed.
But if those folks came through while the policies, the reforms were in place, they weren't subject to the same alleged harm that Booth was subject to.
But they do face a similar risk that the county will revert back to its old.
What's the risk if they're already through the system?
I'm sorry?
What's the risk if they're already through the system?
Well, if they're through the system, then they're no longer class members. But for people who will be magistrated, there's a risk that the county will revert to its old ways.
Well, but is that concrete enough for an injury?
It is, Your
Judge
Honor.
Haynes was saying,
I think a little bit of detail about the way that the district court made its voluntary cessation determination would help. So the the defendants have characterized the district court as ignoring evidence of voluntary cessation, but the district court actually decided a separate motion on evidence of voluntary cessation. Before holding a class certification hearing, Judge Edison ruled on motions to dismiss, including an evidence-based 12b1, making the same arguments that the defendants make here. Judge Edison applied the correct standard and held the defendants hadn't carried their burden to show voluntary cessation. He specifically cited testimony from Judge Foley, Judge Cox, Judge Henry, and then said he would revisit his determination after the class certification hearing, if appropriate. A few weeks later, he held a class certification hearing. He heard testimony from the exact same witnesses, including Judge Henry, Judge Cox, Judge Foley. Their testimony didn't change in any material way, and what the evidence at that hearing showed was that the same reasons he said they hadn't carried their heavy burden a few weeks earlier, they continued to fail to carry that burden from the evidence at the class certification hearing. They continued to insist on the constitutionality of their prior practices. They continued to say those revised bail procedures hadn't been adopted in any official way. The magistrates testified that they weren't bound by the revised bail procedures, and the procedures weren't giving the plaintiffs all the relief that the plaintiffs claimed was constitutional.
Since you only have a little time left, I want to ask you one other thing, which is about the magistrate judges. not being sued in their official capacity, but only their individual capacity. Tell me what you can get out of them.
Well, the magistrates notably don't cite any authority in their letter for the proposition that we don't have standing to get relief from the magistrates in their individual capacity. To be clear, we think it was
Okay, but what can you get?
an injunction against the magistrates.
I understand, but in their individual capacity?
It's true that an individual capacity relief runs only against the person and would follow, for example, Judge Baker out of office rather than run against his office, but it would still give the plaintiffs relief. It would still require him to magistrate the plaintiffs in a way that's consistent with the Constitution.
Okay, how does it make sense that they're not in their official capacity?
Well, Your Honor, I agree that it was error for the district court to dismiss the official capacity claims.
Okay.
In the time that I have remaining, I just want to emphasize that the district court had a sensible case management plan here. The magistrate judge took the motions in an appropriate order, and at the time this appeal was taken, the district court had actually entered a scheduling order, anticipating a full-blown 12B1 motion on mootness, and that scheduling order has been stayed pending the outcome of this appeal. So remand for determination of those mootness issues would be appropriate.
Okay, thank you.
Thank you.
Okay. You got 5 minutes to wrap it up on rebuttal.
Wait for a moment.
Oh, it's okay.
Okay. Thank you, Your Honor. The procedures, we've gone back and forth on whether or not they can recur. I think, Judge Wilson, you already saw the order from the preliminary injunction that says they will not recur. So after a huge hearing, tons of evidence, they will not recur. They've been in place since 2018. The only effect SB 6 could have on it would be to further take discretion away. So if some people are now not bailable, not releasable on personal bond, they can't be affected by this class. And so the mootness argument that's before the court is still before the court. There have been some to correct a couple of statements in the record. There is discretion with this bail schedule.
What about this voluntary cessation notion that it's not been done officially enough? How do you address that?
I think we're still dealing with constitutional violations, Your Honor, and so what they've done repeatedly is to say, we just want a few procedural protections. They've got those procedural protections.
But they're saying y'all can change them at any moment. It's not like a statute passed by Congress.
Right, and at page 11728 of the record, the district court completely disagreed with that statement and said that Galveston County has made significant post-filing revisions to its bail procedures which appear permanent in nature, and if there's any uncertainty, the court holds Galveston County has met its burden to demonstrate that the challenged conduct will not recur. And again, with a forward-looking class, the question always circles back to what you've asked, what the panel is considering is what more do they want? What more could the district court possibly order?
Have y'all talked?
We have.
Okay, because it just seems, I kind of feel like, I don't know, like when a mediation where somebody offers $100,000 and the other side says, well, we won't take less than $100,000.
We did.
And yet they're still litigating. You know, I kind of I realize there's more to it than that. I don't mean to make light of it. It certainly isn't light. But it just feels like something where you all are trying to resolve it, and yet here we are, years later.
Many.
And so I'm just a little confused about why that is. I don't want you to tell me about anything, confidential from a settlement, but what is left that y'all disagree on, I guess, besides all this, standing and mootness and all this, but just in the core of it? And if Mr. X was arrested right now, what is the difference between how the plaintiffs would handle it and how you all would handle it?
I think what I'm hearing today about bail procedures, I honestly don't believe that there's substantively any bail procedure that's currently in place or has been in place in Galveston County since 2018 that's fundamentally disagreed upon, because their suit asked for consideration, individualized consideration, including the ability to pay. That procedure has been in place for years now. I think really what you're going to get down to is whether or not there's a Sixth Amendment claim for having a defense attorney present at the very first appearance in front of a magistrate, which has been teed up and is before another panel in this case. Obviously, we disagree with that being required, since initial magistration is often where you determine.
Well, we have a professional mediator on our staff who is very sophisticated, very able. it strikes me that you ought to be sitting down with that mediator and talking your way through it. You're talking past each other. But I have to confess that not all the difficulty here lies out there. It lies up here. We've created a mess for you. But that said, there's nothing that's standing in the way of working out what are pretty straightforward bail procedures. This is rather old hat, if you excuse the expression. And no one should have an individual stake in this that goes one way or the other. And I think that the guidance of one of our senior people that on the South, that you can move very much toward a conclusion, if not an absolute conclusion, because you're not doing it among yourselves. I see that. And I think we're part of that problem because we're in a lot of transition in the law changing, et cetera, et cetera. So you got a moving target with the law, but you can work that out. What is your reaction to that? Are you amenable to doing that?
We have been ordered to mediate. We did mediate. Both sides appeared before a very able magistrate for mediation, and I believe that was just after class.
Well, I'm not talking about magistrate mediation. I'm talking about our mediator,
Right.
Vic Chenhope, who is a very, very highly trained lawyer with 20 or more years' experience at this, and you work with him and see if you can't work this thing out. You'll get a much more satisfactory solution than you are from the opinions of the court, because we're going to have to move on a difficult field. It's not an open field to run on. There was something called 42 United States Code 1983, which ordinarily would provide, even with the purpose of not acting in a judicial capacity, would certainly have allowed a state official to be enjoined. So that there are some very basic questions here but that doesn't lie with you to resolve. What you can, though, resolve these questions. I have confidence in you. You're a lot of experienced lawyers out there, and everybody has a stake in making it work. And so it's just a matter of finding a commonality to it. If you pardon somebody that's just been in the game a long, long time, I have a lot of confidence in lawyers, but you've got to be talking to each other, enabled to talk to each other. And the court can enable you to do that by just asking you to meet with our mediator. And then you're following a court directive to mediate. Does that work?
If I may respond.
If you want to respond to that and then a short wrap up.
Simply that it's not for lack of trying.
Well, maybe in New Orleans, things feel a little different. But please, if you want to take a sentence or two to wrap up.
Yes, Your Honor. Some of the discussion on the district judges and whether or not they're state actors or acting in a policymaking capacity, trying to take the precedent that we have in the Davis versus Tarrant County and in Daves, I think that's a lot more on point than going further down the road and looking at other actors in other areas. So, with that, thank you.
All right, thank you. We appreciate y'all's arguments, and there is no law that says y'all can't talk as you're walking out the door in beautiful New Orleans. So, with that, you all are excused. And the case is under submission.